All right, everybody, welcome to the Notre Dame Mock Trial 2024 Showcase. My name is Maggie Templeton. I have been a varsity prosecuting attorney for 3 years now, and I am the co-captain of our team. And I think if everyone is ready, we can get started with introductions.
Yes, Your Honor. Good evening, Your Honor. My name is Shekhar Megam, and tonight I will be arguing the pretrial motion on behalf of the people of the state of California. With the court's permission, may my co-counsel please introduce themselves at this time.
Good evening, Your Honor. Maggie Blanchard for the people of the state of California.
Good evening, Your Honor. Taylor Holm for the people of the state of California.
Good evening, Your Honor. Kathleen Sullivan for the people of the state of California.
Good evening, Your Honor. Nikki Zerzanis for the people of the state of California. And with the court's permission, may our witnesses please introduce themselves?
Good evening, Your Honor. My name is Natalie Habrecht, and tonight I am Dr. Amari Sunshine.
Good evening, Your Honor. My name is Adriana Chu, and tonight I am Dr. K.C. Vasquez.
Good evening, Your Honor. My name is Cicely Rumbod, and tonight I am Jerry Moyed.
Good evening, Your Honor. My name is Liz Klein, and tonight I am Detective Nova Perrin.
Good evening, Your Honor. My name is Maddie Masso, and tonight I'll be representing Toby Clark for the pretrial motion. May my co-counsel please introduce themselves at this time.
Good evening, Your Honor. My name is Paige Savage, and I'm representing Toby Clark.
Good evening, Your Honor. Catherine Homberg, representing Toby Clark.
Good evening, Your Honor. Alexandra Charnas, representing Toby Clark.
Good evening, Your Honor. Amelia Gazard, representing Toby Clark. At this time, may our witnesses please introduce themselves?
Good evening, Your Honor. My name is Ilaria Delabate, and tonight I am Arian Sunshine.
Good evening, Your Honor. My name is Allison Yu, and tonight I am Dr. Parker Turner.
Good evening, Your Honor. My name is Jolie Gargis, and tonight I am Nick Yang.
Good evening, Your Honor. My name is Anna Fox, and tonight I am Toby Clark.
Your Honor, at this time, defense would like to exhibit preliminary matters.
Yes, you may.
We would like to enter exhibits 1 through 20, stipulations 1 through 20.
Yes, they will be marked as read into the record.
Do we have permission to move about the well?
Yes, you do. Are there any preliminary matters from the people?
None, Your Honor.
All right, and then just one note, we are going to consider all witnesses as sworn in already. And I think with that, we can start with the pretrial motion. I believe the defense has the pretrial motion.
Good evening. Once again, for scoring purposes, my name is Maddie Masso. I'm here tonight to argue the pretrial motion on behalf of Toby Clark. I'm here today to argue the fact that the geofence is clearly overbroad and in particular. When Detective Perrin made this request, she clearly did not act in good faith due to the size of the geofence and the amount of people it included. She did not act in the way any law enforcement should be allowed to get away with. To start, in the case People v. Dodds, the detective obtained a warrant that spanned 4 other houses, or 328 square feet. The detective in that case also did not take into account that the neighborhood had heavy foot traffic. As a hotel, it is stated the warrant was not sufficiently particular because it did not narrowly tailor the search to the specific crime being investigated. Page 20, line 30. Which is also what Detective Perrin did when she received a geofence warrant that had a radius of 82 feet and a time span of 4 hours. A large issue is brought up when we ask the question why Detective Perrin felt the need to not narrowly tailor the search to the specific crime being investigated. Next, it is clear that this warrant is in particular. In the case U.S. v. Lofstad, the detective obtained a warrant to search through a suspect's phone, yet he never specified what he was searching for. Therefore, the warrant was seen as limitless, and the courts threw it out. In the case at bar, it is clear that the warrant lacks limitations, not only because of its size, which includes 79 people which includes 80 people, but also because it is clearly overbroad due to the fact that it stretches 45 feet outside of Kieran's room. Last, it is clear that Detective Perrin did not act in good faith. She is said to have done 5 other geofence warrants in the past, and yet has chose to not attain the correct amount of warrants.
I'm going to stop you there. If I'm not mistaken, the record indicates that those 5 previous geofence warrants, no one saw an issue with that, correct? So how if Detective Perrin was working in a manner similar to those 5 other cases, and those all passed without any objection, how could this be considered as not in good faith?
Well, Detective Perrin should have taken the time to understand how the geofences work. She should have, as her duty as an officer, she should have kept up with the laws and understood how to obtain the correct amount of geofences and administer it correctly.
Are you saying that good faith means exercising every available precaution or just some of them? And then if you're saying just some of them, where's the bar? Where's the limit? How much is enough?
It means to act without compromising anybody's Fourth Amendment rights. Detective Perrin not only violated the defendant Toby Clark's rights, but also it violated 79 other people in the geofence. If she had acted in good faith, she would have again narrowly tailored the geofence and made it to involve the least amount of people involved in the crime.
So when you're talking about this violation of their constitutional rights, are you saying that geofence as a whole, geofence warrants as a whole are unconstitutional? Or what specifically about this case makes this one unconstitutional?
This geofence is unconstitutional because of the way it was done. Detective Perrin did not get the correct amount of warrants, and this process feels rushed due to the fact that, again, she did not have the correct amount of warrants, and it stretched 45 feet outside of Kieran's room. Again, Detective Perrin did not act in good faith. She is said to have gotten 5 other geofence warrants in the past and yet chose to not get the correct amount. In the case People v. Meza, it states, by asking Google for more information without obtaining a second warrant, ultimately invalidates the warrant. So according to People v. Meza, shouldn't this warrant be invalid? Also, it is also not good faith due to the fact that Detective Perrin chose again to make the geofence a circle and instead could have taken the time to narrowly tailor the process to the crime being investigated. To conclude, it is obvious that this warrant is overbroad and in particular, and that Detective Perrin did not act in good faith. Thank you.
Thank you. Prosecution?
Good evening, Your Honor, and may it please the court. The prosecution moves to deny the defense's motion to quash and allow Exhibit A. All evidence should be admitted because Detective Perrin was sufficiently particular in her warrant and executed the warrant in good faith and with probable cause. Detective Perrin's warrant was sufficiently particular, defined by reasonable temporal and spatial restrictions. In Price v. Superior Court of Riverside County, it states, the warrant was also particularized because it was narrowly tailored in order to minimize the potential of capturing location data of uninvolved individuals. This does not mean that it eliminated every possibility of capturing location data and identifying information of individuals for whom there is no probable cause to believe are suspects or witnesses to the crime. Due to the technology's limitations, the geofence covered all 10 floors of the hotel because customization was only possible for length and width. Detective Perrin made the geofence the size it was in order to take into account the geofencing technology's documented margin of error, 60 to 75 feet.
So regarding the size and shape of the geofence, if we're talking about identifying people near the crime scene, why wouldn't we have the geofence center around the suite? The suite is not the epicenter.
Well, again, Your Honor, the geofencing technology's documented margin of error was 60 to 75 feet, meaning that within the geofence, it could have misplaced people as being somewhere where they weren't. Right. May I proceed, Your Honor?
Yes, you may.
Detective Perrin made the geofence the size it was in order to take into account the geofencing technology's documented margin of error, 60 to 75 feet. Regardless, Detective Perrin efficiently excluded non-relevant individuals within the geofence, executing the warrant to the best of her abilities while navigating these technological restrictions. Detective Perrin consistently demonstrated good faith throughout the execution of this warrant and was completely devoid of any malicious intent towards the defendant. With a commendable 15-year tenure as an officer and 8 years as a detective, she possesses a wealth of experience in handling many geofence warrants. affirming her thorough familiarity with the procedural aspects.
So, how are you distinguishing between the good faith exception and the arguments on breadth and particularity?
Well, Your Honor, particularity is when the detective asked for specific things in the phone, such as their numbers. But breadth is when they ask for something more general.
So, is it your argument that this was both particular and a reasonable amount of breadth as well as falling under the good faith exception?
Yes, Your Honor.
All right, you may continue.
Detective Perrin As a well-seasoned law enforcement officer, Detective Perrin consistently adhered to the procedures which had proven effective throughout her tenure, further exemplifying her status as a well-versed and conscientious law enforcement professional. She not only demonstrated a commitment to good faith through these actions, but her actions were also officially recognized as lawful 2 weeks prior in Price v. Superior Court of Riverside County. Detective Perrin established probable cause in the context of her geofencing strategy, citing the prevalence of cellular devices in the 21st century, a notion underscored in Price v. Riverside County where it states, "The police had probable cause to believe that Price was using a cell phone on the day of the murder, given how common cell phones are in modern society." U.S. v. Grubbs delineates probable cause as the officer's conviction that there is a fair probability that evidence of a crime will be found in a particular place. Detailed within her probable cause statement on page 22, Detective Perrin expressed her belief, stating, "I have probable cause to believe that if the perpetrator carried a cell phone, a geofence warrant would capture information about that cell phone in the vicinity of Kieran's suite, if not inside the suite. I also have probable cause to believe that a geofence centered outside Kieran's suite with about a 75-foot radius would capture all mobile devices in the nearby hallways on the 10th floor and in Kieran's suite." Detective Perrin, grounded in probable cause, asserted not only the likelihood of individuals involved in the case using cell phones, but also the belief that the perpetrator would be geofenced within the specified area and time frame. Your Honor, please take into account the following when considering whether or not to admit Exhibit A into evidence. Detective Perrin's probable cause for obtaining the warrant, the good faith she exemplified while executing the warrant, and the particularity of said warrant. Your Honor, the prosecution once again moves to deny the defense's motion to quash and seeks the admission of Exhibit A along with all associated evidence into the upcoming trial. Thank you.
Great, thank you. Do we have a rebuttal?
Yes. Opposing counsel's argument rests on one case, which is Price v. Riverside. However, the facts of this case cannot be compared to the facts of ours. In the case of Price v. Riverside, it was a shooting, which could have happened from numerous feet away. However, in the case of Barr, it was a stabbing, meaning it would have had to have happened in the room with the victim. Also, Detective Perrin had no reason to make the time frame 4 hours, when a stabbing could have taken place within 10 minutes to an hour. Perrin should have done her research before obtaining the warrants and making a geofence. This process feels rushed only by the amount of warrants she got, which is not the correct amount, and due to how large and not particular the geofence was. Again, this warrant is clearly overbroad due to its size and clearly needs to be excluded from the case. Thank you.
Prosecution?
Your Honor, the opposing counsel's argument rests on 3 cases: People v. Dawes, U.S. v. Lofsted, and People v. Mesa. People v. Dawes says that the geofence was too large, at least that's what opposing counsel uses it to explain. But the reason Detective Perrin made it as big as it was to take into account the margin of error, which again was 60 to 75 feet. Lofsted set the precedent for what Detective Perrin should have done when obtaining the warrants, and Detective Perrin followed it, meaning that in no way was she breaking any laws or doing anything considered not in good faith. People v. Mesa Opposing counsel uses People v. Meza to explain that Detective Perrin's investigative research should have been invalidated because she didn't obtain the correct amount of warrants. But Detective Perrin was only doing the things that she had done prior to this investigation, which had always worked for her in the past. Your Honor, the prosecution once again moves to deny the defense's motion to quash and seeks the admission of Exhibit A into the following trial. Thank you.
All right. So with that, I'm going to rule on the pretrial motion. I think both were well argued, but unfortunately, I think with the good faith exception, you just have so much room to argue based on to argue and allow the exhibit in. So I am going to quash the motion and allow Exhibit A into trial. Yes, of course. Right, at this time, are the people ready to present opening arguments?
Yes, Your Honor. Two can keep a secret if one of them is dead. On the morning of July 16th, Toby Clark learned that Kieran Sunshine didn't want to keep their secret anymore. And the very next morning, Kieran Sunshine was dead. Toby Clark, Kieran's ultimate betrayal forced her to make the ultimate decision: convince or kill. Kieran Sunshine, the victim of this case, was CEO of Sunshine Medical Components, or SMC. As CEO, Kieran worked with SMC's in-house counsel, the defendant, Ms. Toby Clark, to develop and patent the Forever Flex, a prosthetic joint replacement. This was all in preparation for the IPO board meeting on July 17th, when they would announce the company going public. Because, as you will hear tonight, SMC was nearing bankruptcy, something which they believed they could solve through the Forever Flex and its profit. However, it will be revealed that this collaboration was defined by a secret. The Forever Flex was fraudulent, causing bacterial infections in test subjects, something which both the victim and the defendant knew and purposefully concealed. However, everything began to change on the morning of July 16th, when Kieran told Toby he was going to tell the truth about the fraud to the board, jeopardizing everything that he and Ms. Clark had worked for. The people will prove that in this moment, Ms. Clark felt she had to make a decision: convince Kieran to keep the fraud a secret or kill him. People will show that she returned to Kieran's suite later that night with this choice in mind. And after she failed to convince Kieran one last time, she took the very same champagne saber she had gifted Kieran earlier that day and stabbed him in the abdomen. The ultimate decision made. Tonight, the people will call 4 witnesses to the stand. Detective Nova Perrin, investigating officer, will describe an investigation that was proper, logical, and appropriately eliminated any suspects beyond the defendant. You will hear from Jerry Moyad how she heard the defendant's implicating statement: if this doesn't get fixed, there is going to be a bloodbath, as well as an argument between the victim and the defendant right before the murder. Dr. Casey Vasquez will testify to how a shoulder wound claimed to have hindered the defendant actually had no impact on her ability to wield the weapon. And finally, you will hear from Amari Sunshine, a sibling of the victim and SMC employee, how she saw the defendant walking to Kieran's room right before the murder. Ms. Clark was betrayed by Kieran Sunshine, which led her to that ultimate decision. One way or another, she could not let that secret leave that hotel room. And by the time my colleagues, Ms. Sullivan, Ms. Holm, and I have rested our case, it will be clear to this court just what the defendant chose to do. The defendant chose to kill. She not only committed the act that ended Kieran Sunshine's life, but did so deliberately, willfully, and with premeditated intent, therefore meeting our burden of proof beyond a reasonable doubt for all elements under CalCrims 520 and 521. Therefore, we will ask for a verdict of guilty of the charge of first-degree murder. And after hearing the evidence tonight, I'm confident that you will return with a guilty verdict. Thank you.
All right, defense.
Your Honor. The people just described the testimony and physical evidence that will be presented tonight. What they fail to mention, and what will soon be revealed, is that all that testimony and all that evidence doesn't prove a murderer, and instead proves three simple truths. Toby Clark is caring, Toby Clark is trusting, and Toby Clark always works to do the right thing. When you look at who Toby Clark is, and always has been, the people's case leaves immense reasonable doubt. Toby's longtime friend, Nick Yang, will attest to Toby's kindness as a lawyer supporting those affected by medical malpractice. In doing so, they will offer examples as to Toby's history of declining opportunities for financial gain, and prove to you that she was never in it for the money. Moreover, Dr. Parker Turner will describe how the people have gotten ahead of their own evidence and explain that Toby Clark couldn't have dealt the fatal blow without significant pain and difficulty. Instead, you will hear about someone spiteful, someone proven untrustworthy, and someone who's gone out of her way to go against what is right. Kieran's elder sister, Amari Sunshine, had the same means, the same opportunity, and even more motive to make sure Kieran never left his hotel room that night. Our first witness, and the youngest of the Sunshine siblings, Aryan, will take to the stand and testify to Amari's past attempts to interfere with Kieran's success. You will hear that Amari owned the same type of shoes that Toby did, and even wore the same size. You'll hear that Amari had the same access to the saber, and was located just down the hall from Kieran's suite that night. And you'll hear about how Amari mocked and belittled Kieran's ideas for years, constantly trying to undermine his accomplishments. Amari had a constant undercurrent of resentment, pulled far from the past. Killing Kieran would simply correct the mistake their father had made when he promoted Kieran to CEO. Tonight, you will hear that the only reason Amari Sunshine isn't on trial is because two others failed to do the right thing. Detective Nova Perrin failed to investigate Amari as thoroughly as she should have, even after naming her a person of interest. You will hear that Jerry Moyed, biased and historically dishonest, made assumptions and jumped to conclusions about what happened in a room she wasn't even in. Your Honor, this isn't a case about a choice Toby Clark made. This is a case about a compassionate and virtuous lawyer being put on trial for a murder she had no involvement in. By the time Ms. Krensavage, Ms. Holmrig, Ms. Charnas, and I have rested our case, it will be clear who Toby Clark is. Toby Clark is the kind of person who would buy her friend an expensive bottle of champagne and a champagne saber to celebrate what she thought was a moment of triumph. Toby Clark, the kind of person who would donate her shoes to charity. Toby Clark is the kind of person who, when she learned of the fraud, attempted to convince her partner to come clean. And Toby Clark, the kind of person who, when Kieran made it clear he would not do so, resigned herself to leaving the company rather than becoming invested in a lie. That is the Toby Clark you will hear about tonight. That is the Toby Clark you will see tonight. And that is why the defense asks that you find Toby Clark not guilty of first-degree murder. Thank you, Your Honor.
Thank you. All right, would the people like to call their first witness?
People would like to call Detective Nova Perrin to the stand.
Good evening. Please state your name and occupation for the court.
My name is Detective Mo Perrin. I have been in law enforcement for a little over a decade. 7 of those years as a detective for the Kings County Police Department. I have special certifications in forensic investigation, analysis, and crime scene forensic training.
What, if any, involvement do you have in the case at hand?
Well, as the lead investigator for this case, I responded to a call from the Bells Hotel on the morning of July 17th, 2023.
And upon your arrival at the scene, what was your first course of action?
I met Jerry Moyad, the victim's life coach, outside of the suite, and I then entered the scene.
Do you recognize what has been marked as Exhibit C?
Yes, I do.
What is it?
This is a diagram of the crime scene that I investigated.
Is it a fair and accurate depiction of your diagram?
It is, yes.
Your Honor, I ask that the diagram of the crime scene be moved into evidence as People's Exhibit C.
Any objection?
None, Your Honor. Now, let's talk about the body. In what condition did you discover it?
I found the body on his back in the suite living room. There was a stab wound to the upper right side of his abdomen and a pool of blood next to the body. And based off of the discoloration of the skin, which we call the lividity, I determined that the body had not been moved after the death took place.
Objection, Your Honor. Improper witness testimony. Your Honor, may I respond?
Yes, you may.
This statement does not fall under any objection. According to Stipulation 3, my witness, Detective Nova Perrin, has special certifications in forensic investigation and is able to make a legitimate and unbiased opinion on the body. May I respond?
Yes, you may.
Your Honor, while this defendant does have those qualifications, they do not have the qualifications of a medical examiner, meaning that they cannot testify to the validity of the body.
I think with the experience they've established earlier in their testimony tonight, I am going to overrule the objection.
Now, did you observe anything else at the crime scene besides the body?
Yes, within the pool of blood, I found a saber, and I was able to collect fingerprints from those. There were also shoe prints from the body of the deceased. It was a 41 to 42 European size Magnate tennis shoe. And on the victim's suit jacket, there were 5 red and blue mixed silk fibers.
I'd like to come back to the evidence, but for now, I'd like to talk about how your investigation proceeded after collecting said evidence.
Yeah, after securing the scene, I decided to set up interviews with all of those people that were close to the victim. It was Jerry Moyad, Arian Sunshine, Amari Sunshine, and Toby Clark in that order.
And how did these interviews inform the next steps in your investigation?
From Amari, I learned there had been tensions between Clark and the victim, and Amari voluntarily came into the station. She volunteered that she didn't own any silk but had lost their magnates. She also claimed to have seen Clark going into the direction of the victim's suite around 11 p.m. But most notable from the entire interview process was when Toby Clark voluntarily came into the station and gave DNA and fingerprint samples.
Did you learn anything more about the night of July 16th from Toby Clark?
Yes, I learned that Clark and the victim had a scheduled meeting around the time that Ms. Moyad had heard an argument.
And based on everything you had learned up until that point, what did you decide to do next?
Well, what I had learned from my interview, I wanted to focus on Clark as a suspect and Amari Moore as a person of interest. However, my subsequent work led me to completely eliminate Amari as I had no evidence against them.
And what was that said subsequent work?
I executed a geofence warrant and asked for all cell pings within the area around 11 p.m.
Could you please explain what geofencing is?
Yeah, sure. Geofencing is a virtual perimeter tool. It uses the pings off of cell phones to cell towers to track location of somebody. And in my experience, I have used geofence warrants 5 different times, and I've never encountered an issue, and all of them have led to positive suspect identification.
Do you recognize what has been marked as Exhibit A?
I do.
What is it?
This is a diagram of the 10th floor of the Bells Hotel, including the geofence I executed.
Is it a fair and accurate depiction of your diagram?
Yes, it is.
Your Honor, I ask that the diagram of the 10th floor of the Bells Hotel be moved into evidence as People's Exhibit A.
Any objections?
You mentioned earlier that you focused on Miss Clark as a suspect. Could you please elaborate on why?
I had an overwhelming amount of evidence against them, and based off of this, I obtained a search warrant for their house.
And what, if anything, did you find at Mrs. Clark's home?
I found a silk scarf, a red and blue silk scarf, and the fibers were forensically consistent with the ones found on the victim's suit jacket. That was confirmed by the medical examiner. However, when I was there, Clark said they used to previously own magnates but claimed to have donated them prior to my arrival.
And ultimately, after learning of all this evidence, what were you led to do?
All evidence connecting Clark to the crime, I had no choice but to focus on them as my sole suspect. And I had no other choice. You know, they were the first person.
Thank you, Your Honor. No further questions.
Right, cross-examination.
Yes, Your Honor.
Good evening, Detective.
Good evening.
The evidence that led you to obtain a search warrant for the Clark's home consisted of her location on the geograph, correct?
And according to Amari.
And also information you obtained based off those statements, correct?
Yes.
You then executed a search warrant for Toby Clark's home, right?
I did.
And upon searching the residence, you were looking for a pair of magnate shoes and a silk scarf, correct?
I was, yes.
But isn't it true you never found a pair of magnate shoes?
No, they claimed to have donated them.
Now, let's move on to the geofence. The geofence did not extend into Amari Sunshine's room. Now, did it?
No, it didn't.
So if Amari left their phone in the room, it would not have pinged, would it?
No, I didn't feel it was necessary to include Amari into the geofence.
And the reason it would not have pinged is because the geofence works by pinging off of a phone's cellular location, correct?
Yes, that is true.
So if a person's not with their phone, their location cannot be tracked, can it?
Not accurately.
And isn't it also true the geofence has a margin of error of 60 to 75 feet?
Yes, that is true in rare circumstances, but I've never come across that in my professional career.
Now, let's move on to the physical evidence. There were 2 sets of fingerprints on the saber, correct?
Yes.
And isn't it also true the second set was never identified?
Wasn't able to be identified because of the nature of the prints. Not all prints are able to be identified. It's just how forensics works.
And since they were unable to be identified, they did not match the defendant. Now, did they?
No.
Now, let's move on to the scene of the crime. You named Amari Sunshine a person of interest in this case, correct?
I did, yes.
But you never obtained a search warrant for his own, did you?
No, I had no evidence against them other than possible magnates, but that's not enough to convict somebody of a crime.
Well, now at the scene of the crime, there was a bloody shoe print, right?
Yes.
And it was a magnate shoe print. Isn't that right?
Yes, it is.
And it was a size 41, 42, correct?
European, yes.
And isn't it true Amari owned magnates within that range?
Yes, all 3 of them own shoes within that size range.
But they never provided these shoes to you. Now, did they?
No, but neither did Toby.
And you couldn't search the residence for these shoes. Now, could you?
I chose not to because that was the only piece of evidence I had against them. It's not enough for a search warrant.
Oh, I'm sorry. Okay. And you also couldn't search his residence for a silk scarf, correct?
I chose not to, but yes.
Now, going back to before you searched the scene of the crime, Jerry Moya told you that they saw a blue latex glove in the hotel hallway, correct?
Yes, by the elevators.
But you never found the glove, did you?
No, I was focused on the crime scene, not the exterior of the hallway.
So now let's go back to Amari Sunshine once again. You were aware that Amari Sunshine stood to inherit Kieran's financial interest in the company, correct?
Yes, but Toby Clark had an emotional incentive as well.
So if Amari stood to inherit these shares, he stood to gain a financial interest if Kieran was gone, correct?
Yes, that is true. However, emotional incentives are quite as strong.
Thank you, Your Honor. I have no further questions for this witness.
All right, any redirect?
No redirect, Your Honor. I ask that my witness please be excused from the stand.
Yes, they may. Thank you. Would you like to call your next witness?
Yes, Your Honor. The people call Jerry Moyad to the stand. Good evening, Ms. Moyad.
Wonderful evening.
Please state your name and occupation for the court.
My name is Jerry Moyad, and I'm a Pisces, which is a little awkward because I'm also a pescatarian. I've been on this earth for 39 wonderful years, and I'm a holistic wellness coach and former personal advisor to Kieran Sunshine at SMC for 5 splendid years.
And did you ever work with Toby Clark, the defendant?
Yes. All employees at SMC are required to meet with me about once a month. But outside of those meetings, I do not choose to share my aura with someone that thinks that my practices are woo-woo stuff.
And what, if anything, of significance happened on the morning of January 3rd?
Well, I saw Kieran go into Toby's room in the late morning and close the door. They were in there for about an hour, but when Kieran came out, he looked like he aged 1,000 years. After that meeting, Kieran became much less excited about the Forever Flex release and much more snappy. Toby, on the other hand, became much more excited about the Forever Flex release and worked later hours.
And did you ever find out what was bothering Kieran?
Yes. I had a meeting with Kieran on June 2nd where he revealed to me that he was worried if the Forever Flex didn't work out, the company would go bankrupt. He told me that he received a report on January 3rd that said that the Forever Flex was causing infections in the test subject, but Toby convinced Kieran to lie to the board.
And what, if anything, of significance happened on the morning of July 16th?
Well, on July 16th, I was in my dining room to Kieran for the IPO meeting that was supposed to happen that day, and I woke up around 9 a.m. to auras clashing in Kieran's room. I heard Toby say that Kieran would get the both of them in trouble, and Kieran say that this was his final decision.
And did you interact with either of them afterwards?
I didn't get the chance to interact with Toby because I saw her storm out of Kieran's room through my peephole. I did get the chance to interact with her later on. I did get to talk to Kieran after that altercation, and Kieran told me that he revealed to Toby that he will be telling the truth to the board, and I am very
Objection, Your Honor. Hearsay.
Your Honor, may I respond?
Yes, you may.
This falls under the exception of, excuse me one moment. I believe this falls, sorry. This falls under the exception of state of mind, as it is a statement of intent that he's going to tell the truth to the board.
Actually, Your Honor, I am referring to he told Toby. The existence of the conversation between Toby and Kieran is a statement of fact that Kieran allegedly told Ms. Moyad that the prosecution is using for the truth of the matter.
What was the statement again?
That Kieran told me that he was going to tell the board.
No, that he told Toby he was going to tell the board. You cannot.
Okay.
Prosecution cannot bring conversation, regardless of content, between Toby and Kieran. The alleged conversation is being used for the truth of the matter.
Your Honor, may I respond?
Yes, you may.
This would fall under the exception of adoptive admission, as far as the people know. Toby Clark will not deny that this conversation happened. Therefore, we ask that you suspend your ruling until after the defendant testifies, as we will not be able to recall Ms. Moyad to the stand later due to the rules of mock trial. And so therefore, it would fall under the exception of adoptive admission, as we believe that Ms. Clark is going to testify to the fact that they did, in fact, have this conversation.
Okay, yes. So with the inability to recall witnesses, I'm going to suspend a ruling on this until after Ms. Clark's testimony.
Thank you, Your Honor. Did you get a chance to finish your response?
Yes, I believe I did.
Thank you. And you mentioned you saw Toby later that day. When was that?
At around 1 p.m., I was right outside where they were having the IPO meeting, And Toby stormed out and yelled, "If this doesn't get fixed, there's going to be a bloodbath." And she seemed like super surprised to see me there. And after that, Kieran walked out right after Toby. So I believe that that statement was meant for Kieran.
And did you see them together at any other point during the day?
No, but I do believe I heard them.
What do you mean?
At around 11:10 p.m., I was getting ready for my everything shower, and I heard a loud arguing coming from Kieran's room. I heard Kieran yell, "No!" and another voice yell, "You would ruin everything!" And I believe that that voice was Toby Clark.
And when was the next time that you saw Kieran Sunshine?
Well, I woke up at around 8 a.m. for our morning yoga, and I walked into Kieran's room and saw him there in a pool of blood, dead on the floor, his spirit floating into the next life.
Thank you, Ms. Moyad. Your Honor, I have no further questions at this time.
Cross-examination?
Yes, Your Honor. Good evening, Ms. Moyad.
Wonderful evening.
You said on your resume that you have a degree in integrative wellness from a college, is that correct?
Yes, that is correct.
But you don't actually have that degree, now do you?
No, I was worried that if I didn't put a degree down, I wouldn't be accepted to this position.
So you lied?
Yes, I did.
And Kieran forgave you for lying?
Yes, after 6 months of working at SMC, I immediately told Kieran and he immediately forgave me.
You had a close relationship with Kieran, didn't you?
Yes, very close. Our spirits were intertwined.
You did not, however, have a close relationship with Toby Clark?
No, unfortunately, I wasn't able to get to know her because she believed that my practices were woo-woo stuff.
And you didn't particularly trust Miss Clark?
Unfortunately, no.
Let's move on to the bloodbath comment you heard from Toby on July 16th. You don't know who that comment was about?
I'm 99% sure that it was about Kieran, but no, not positive.
And Toby Clark never mentioned Kieran's name?
No.
Later that evening, around 11:10 p.m., you were getting ready for a shower, is that correct?
Yes, I was. I am not able to sleep without a shower before bed.
And you heard what you assumed to be arguing coming from Kieran's room?
Well, I heard loud screaming, so yes, I would say that's an argument.
But you never entered the room yourself?
No, I mean, I was taking a shower.
So you say in your statement that you assumed that one of the voices was Toby's, but you can't tell me with 100% certainty that that was correct?
Well, after working with Toby for 5 years, I feel like I would be able to tell her voice, but unfortunately I couldn't hear fully, so no.
And you cannot tell me what exactly the conversation was about?
No, but it's definitely about something serious.
And you never entered the room to see yourself until the next morning when you found Mr. Sunshine dead?
Yes.
At the crime scene, you spotted a latex glove in an open trash can, is that correct?
Yes, I assumed it was from one of the hotel workers.
But you didn't think that was important?
No, yet again, I thought it was about one of the hotel workers.
Thank you, Ms. Moyad. Your Honor, I have no further questions.
Any redirect?
And Your Honor, may your witness please be excused?
Yes, she may.
Your Honor, can you call Dr. Casey Vasquez to the stand?
Please state your name and occupation for the court.
My name is Dr. Casey Vasquez, and I've had the pleasure of working with the county for almost 20 wonderful years on numerous criminal cases. In these, I specialized in complicated forensic evidence, which I must admit is my favorite.
Would you briefly describe your academic background?
Certainly. After receiving my bachelor's degree at Boston University, I went on to medical school at the University of Washington. However, I felt a calling towards forensics and completed my forensic pathology residency at the Denver office of the medical examiner. I then completed my fellowship at the University of Michigan. What a journey.
What, if any, involvement do you have in this case?
I arrived at the scene at 8:30 a.m. to examine the body of Mr. Sunshine, which is when, based on the degree of rigor mortis, I was able to conclude that he had died between the hours of 10 p.m. and 2 a.m. on the night of July 16th. I later conducted the autopsy to determine the manner and cause of death and assess the physical evidence collected by Detective Heron.
And what did you conclude was the manner of death?
In my professional, and I cannot emphasize that enough, professional opinion, the manner of death was homicide, the cause being hemorrhaging due to a stab wound in the victim's upper right abdomen, penetrating his liver.
Were you able to gather any information on the weapon used based on the wound you examined?
Ultimately, my examination supports the conclusion that the bloody champagne saber found at the crime scene was the weapon that caused the death of Mr. Sunshine. My measurements of the width and depth of the wound revealed it to be 1.5 inches wide and 6 inches deep, which is consistent with the saber size.
Are you aware of the defendant's previous shoulder injury?
Yes, I examined the MRI of Miss Clark's shoulder.
In your opinion, could the defendant have inflicted this wound?
Certainly. See, the saber weighed only 2.5 pounds, and its point and sharp edge could easily cause a deep wound found in the victim, meaning that despite the presence of scar tissue, they would have still been able to handle the saber in a lethal manner.
Now, at the beginning of your testimony, you mentioned examining physical evidence. Were you able to gather any information based on this examination?
Yes, a partial bloody shoe print found at the crime scene that matched the shoe size of Miss Clark. Additionally, silk fibers found on the victim that matched the silk scarf in possession of Miss Clark. However, since there is no way of knowing when the fibers were transferred, I was much more satisfied with what I found from the fingerprints on the grip of the saber.
And what was that?
I'm so glad you asked. There was a second set of fingerprints on the saber, closer to the saber's blade, that even after digital enhancement were too fuzzy to identify as belonging to any individual in this case or anybody in the national database. However, I was able to identify a set of fingerprints as conclusively belonging to Miss Toby Clark.
Thank you, Dr. Vasquez. No further questions, Your Honor.
Cross-examination?
Yes, Your Honor.
Good evening.
So first I'd like to ask about the fibers found in Kieran's skin. Now, it's impossible to know those fibers were transferred, correct?
Yes, that is impossible.
So Kieran gave that scarf to Toby that morning, and Kieran was wearing the same clothes that he passed away. Is it possible that the fibers were transferred then?
Yes, that is very much possible.
So now moving on to Toby's shoulder injury. You had an opportunity to examine the MRI of Toby's right shoulder, correct?
That is correct.
And that MRI showed significant scar tissue on the right rotator cuff?
Yes, because that is what happens when you have an injury.
Correct. Scar tissue forms after a person suffers an injury. And it's your opinion that that Kieran is stabbed with the champagne saber found at the scene?
In my professional opinion, yes.
Right. And that saber was 2.5 pounds? Correct?
Yes, that is correct.
So, a weapon that light would require sufficient force to inflict a deadly wound.
Yes, that is correct.
So now moving on to the footprint. Now that footprint was badly degraded, correct?
Yes, very much so that I was unable to determine the height and weight of the person.
Correct. And in terms of sizing, your best guess was between 41 and 42 European?
That is correct.
But you're aware that in addition to Toby, Amari and Jerry both have shoe sizes in that range, correct?
Yes, I am aware of that.
So now moving on to the fingerprints. You were able to match one set as belonging to Toby Clark.
That is correct.
And you're aware that Toby handed the saber the morning of July 16th?
Yes.
When she gave it to Kieran?
Yes, I am aware of that event.
And it's impossible to know when fingerprints are placed on an item, right?
Yes, like the fibers, it is impossible.
So there wasn't anything about the fingerprints that suggested they were placed the evening of July 16th, were there?
No, there weren't.
So moving on to the second set of prints, you were unable to identify them initially.
Yes, even after digital enhancement.
Correct. You couldn't match them to Kieran or Toby or anybody else in the States.
That is correct.
So what you're telling this court is that there are unidentified fingerprints on the murder weapon?
Yes. Well, I ran it through every test and I was, like I mentioned earlier, unable to identify it as belonging to any individual in this case.
So it's yes.
That is correct.
Thank you. Your Honor, I have no further questions.
All right, any redirect?
No redirect, Your Honor. May the witness please be excused?
Yes.
At this time, the people call Amari Sunshine to the stand. Good evening, Dr. Sunshine.
Good evening.
Please state your name and place of occupation for the court.
My name is Dr. Amari Sunshine, and I work at Sunshine Medical Components.
And what connection, if any, do you have with the victim?
Was Kieran's oldest sister, but I was also his colleague at SMC.
And during this time, what was your role at SMC?
My role at SMC was Vice President of Research and Development. My job mainly consisted of managing engineering teams and reviewing their data. My interest has always leaned more towards science than business.
And did you have any ownership of SMC while Kieran was CEO?
Yes. In fact, I had 50% ownership of the company. And while he was still alive, Kieran had 30%, and Aryan 20%.
Now, Dr. Sunshine, is there anyone in the courtroom today whom you recognize from your time at SMC?
Yes. Defendant, Toby Clark. She is seated at the defense table wearing a maroon blouse and a black blazer.
Your Honor, at this time, I ask the record reflect that the witness has correctly identified the defendant, Toby Clark. And what relationship, if any, did you observe between the defendant and the victim?
They seemed very close in the beginning, but in the months prior to his death, it was visibly obvious their friendship had changed.
Now, what change did you observe?
Well, Kieran and Toby met on January 3rd, and from that point on, something felt off. Kieran looked wary, but Toby, however, grew busier with work than she had ever before, constantly taking meetings with suppliers regarding the Forever Flex. She appeared more confident than ever, but slightly frazzled upon further analysis.
Now, did you ever receive any information regarding the Forever Flex?
Yes. On February 13th, I received a heavily redacted report on the Forever Flex. I could not understand much of the information, so I asked Kieran about it. But he suddenly lashed out at me, telling me that Toby and he were handling things. I was beyond confused by his behavior.
And did you continue to look for information after that?
Yes. I found out that Toby had signed off and was trying to expedite the patent for the Forever Flex.
Objection, Your Honor, hearsay.
Your Honor, may I respond?
Yes, you may.
This falls under the exception of records made in the regular course of business.
Your Honor, may I respond?
Yes.
The details of that exception include that this witness the person who signed it may be reliable, and the prosecution has clearly on multiple times painted Toby unreliable. The prosecution cannot in one breath say the defendant is reliable, and then in the next say they're not.
Your Honor, may I respond?
Yes, you may.
The defense calling their own client untrustworthy aside, the exception does not state that the person who signed it needs to be trustworthy, only that the records came from a trustworthy source, and as this is a patent application, which is a government document, I think it can be assumed that this is a trustworthy source.
Your Honor, may I respond?
Yes.
Like the prosecution has just said, the source must be trustworthy, and not only am I not calling my own client untrustworthy, I'm just repeating what the prosecution has laid out. In addition, I will restate, the prosecution is trying to say that my client, aka the source of the signature, is untrustworthy. As I said before, the prosecution cannot in one breath say that my client is untrustworthy, and in the next they are.
Oh, right. So you are discussing a statement from the patent for the Forever Flex,
Yes, the
correct?
source of this patent, which is the signature.
What is the statement itself?
This, as this witness just testified, they said the signature came from Toby Clark.
That is not, I believe, what the witness just testified. The witness testified that they found out that Toby had signed off on and was trying to expedite a patent.
So I don't believe that is an explicit statement, more of an action, and therefore not a statement made, not hearsay in general. Do you have another objection to make or amend? Okay, in that case, I'm going to overrule the objection.
Thank you, Your Honor. And did you get a chance to finish your response?
I did.
Thank you. So you decided to question Toby about it, and how did that go?
Toby, like Kieran, claimed everything was under control. However, I was concerned something was suspicious about this whole situation.
Now, moving on to the night of July 16th, 2023. Where were you?
I was residing at the Bells Hotel because SMC was having their IPO board meeting regarding Forever Flex the next day.
And what, if anything, of significance happened that night?
At around 11 p.m., I heard blaring voices coming from the hallway. I'm an extremely light sleeper, so all that ruckus was very much disturbing me. So I looked into the hallway to see what the commotion was.
And what, if anything, did you see?
I saw none other than Toby turning the corner into the north hallway. It seemed that they were going to Kieran's room at the end of that hallway.
And did you see Kieran at all that night?
No, I did not see Kieran at all that night. After Toby left, I went back to bed to get proper rest for the board meeting the next day, but unfortunately, no amount of sleep could prepare me for discovering that the next day that my brother was dead.
Thank you, Dr. Sunshine. Your Honor, no further questions at this time.
Cross-examination?
Good evening, Dr. Amari Sunshine.
Good evening.
Isn't it true you owned a pair of 9-8 shoes?
I did.
And isn't it also true that you never provided these to the detective?
That is true because I lost them.
Now, let's realize the relationship between you and your brother. Isn't it true you had a different idea on how to continue your father's legacy than your brother Kieran?
Yes, we had different ideas.
You even went as far as to pull so-called pranks on your brother, didn't you?
Yes, I did.
Objection, Your Honor, vague and ambiguous.
Your Honor, may I respond?
Yes, you may.
Your Honor, this question is not vague and ambiguous because I'm just asking a question about pranks. It's not vague or ambiguous at all. The question is the pranks, did you see pranks? Did you do pranks? Yes or no?
I do believe with the yes or no answer, it does not fall under this conviction. So I'm going to
Would you like me to repeat the question?
No, thank you.
All right, so now let's move on. And then before the company was, as the company was taking off, your brother was the CEO, correct?
He was.
And the company was during bankruptcy before your brother died.
It was close to bankruptcy, yes.
So if the company did go bankrupt, your shares would become worth less than if the company was succeeding, correct?
That is correct.
And then you became CEO of SMC. Isn't that right?
Yes, after my brother died.
Now, let's move on to the night and day of your brother's murder, July 16, 2023. That morning, you set foot in the Kieran's Hotel suite, correct?
I did, correct.
And that's when you saw the champagne saber, correct?
Correct, on display on the fireplace.
And you even made a comment about the saber.
Yes, I said it was frivolous.
Now, let's move on to later that night. Around 11 p.m., you got out of bed, correct?
Correct, to blaring voices in the hallway.
And you were, as you testified earlier, you were a light sleeper, correct?
I am, extremely light sleeper.
And that's why you went out in the hallway when you heard something, correct?
Correct.
And then after checking out what you saw, you went back into your bed, correct?
Correct, to get proper sleep for the board meeting.
So that's just despite hearing the loud noises in the hallway, correct?
That is correct.
So just to recap, your story is that you were alone, sound asleep, in your room for the rest of the night, correct?
Yes.
But there's nobody that can corroborate your location, is there, Amari Sunshine?
There is not.
Thank you, Your Honor. I have no further questions for this witness.
Any redirect?
Yes, Your Honor. Amari Sunshine, did you kill your brother, Kieran Sunshine?
Absolutely not. I would never kill my own brother.
Thank you, Dr. Sunshine. Your Honor, I have no further questions. May this witness please be dismissed?
Yes, they may.
And at this time, the prosecution rests.
Right. Would the defense like to call their first witness?
We would, Your Honor. Defense would like to call Arian Sunshine to the stand. Good evening, Arian Sunshine.
Good evening.
Would you mind please stating your name and occupation for the court?
My name is Arian Sunshine, and I am VP of Marketing at SMC.
Do you know Arian Sunshine?
Of course, he was my older brother. He was also the CEO of SMC, so we used to work together.
And did you get along well with your older brother, Kieran?
I'd say we got along pretty well. I always admired he was good at the business side of things and the way that he received a scholarship to his dream college.
And do you have any other siblings?
Yes, I have another older sibling, Amari. He was VP of Research and Development, but has since taken over the company due to recent events.
And based off your observations, did your siblings seem to get along well with each other?
Not at all. Growing up, Amari would always pull these pranks on Kieran that were just hurtful.
Can you elaborate on what you observed?
Yes. Once, Amari had received the acceptance letter from his dream college. Kieran had received the acceptance letter from his dream college. Amari then blocked the email, making it impossible for Kieran to even find out Once he did, he felt rightfully upset, and Amari just laughed.
Objection, Your Honor. This is character evidence which pertains to demonstrating a person's character traits or tendencies. Such evidence is inadmissible when used to prove that a person acted in accordance with such traits on a specific occasion. The defense is attempting to use this evidence in such manner.
Your Honor, may I respond?
Yes, you may.
Well, this is character evidence that falls under the exception of a witness's character, which proves dishonest behavior through specific incidents of conduct, which is the definition of this exception.
Your Honor, may I respond?
Yes.
This statement is not being presented to prove that Amari was dishonest.
Your Honor, may I respond?
Yes, you may.
Well, the act of hiding something from someone else is dishonest. You are deliberately not telling that you have done something.
Any response? In that case, I am going to overrule the objection.
Thank you, Your Honor. So, and did this relationship seem to improve as you and your siblings matured?
No, I constantly found myself refereeing my own siblings, more so when we got older because Amari would joke about Kieran plummeting the company, especially regarding the product of Forever Flex.
And can you briefly elaborate on your relationship with Amari?
Dad stated in his will that if something happened to Kieran, Amari would take over the company, which ruins an already fractured relationship because of all the jokes he would make about me and Kieran plummeting the company.
And are you aware of any more instances of notable tension between Kieran and Amari?
Yes, I believe in late May something occurred.
Thank you. Now moving on. Do you know the defendant, Toby Clark?
I worked with her. We're not that close though.
And where were you on January 3rd, 2023?
I was at work at SMC.
And on January 3rd, 2023, do you remember Toby and Kieran's interactions?
I don't recall much except for Kieran rushing into Toby's office. And then I noticed a drastic change in both of their behaviors.
And how so?
Toby appeared cheerful and Kieran was the opposite. He was snapping at everybody, and I also didn't see them hang out as much as they used to.
And are you familiar with the Forever Flex?
Yes.
And were you aware of any issues surrounding the product?
I wasn't aware of any particular issues except for financial ones, as budget cuts had to be made.
Now, let's move on to July 16th. Did you set foot into your brother's hotel suite?
I did. I went to go see if he needed help setting up with anything. He then showed me the saber that Toby gifted him. I never touched it, though.
And after your brother's horrible death, who obtained leadership and the shares of the company?
Amari did.
And so then, who is now the current CEO of the company?
Amari is.
Thank you, Your Honor. I have no further questions for this witness.
All right.
Upon his death, your father left you 20% of the shares in his company, correct?
That is correct.
Then in his will, Kieran left his shares and his CEO position to Amari.
Yes, he was better at those things, so it made the most sense.
And when the company faced budget cuts, you were forced to make cuts first.
Yes.
You even claim when you were younger, Amari had told you were the least favorite child.
He did say that. It was hurtful, but, siblings are siblings.
Moving to July 16th, you went to Kieran's suite that day, correct?
Yes, I did. I went to see if he needed help setting up with anything.
And he showed you the saber?
Yes, he did. He was very proud of it and excited about the Forever Flex.
You did not touch the saber, correct?
Absolutely not.
Around 1 p.m. the same day, you saw Toby Clark.
Yes.
And you heard her say, if this doesn't get fixed, there's going to be a bloodbath.
I did hear that expression, but taken out of context, it can be super rash, and I had no idea what it was actually pertaining to.
Thank you, Your Honor. No further questions.
All right. Any redirect?
Yes, Your Honor. Let's go back to the statement about the bloodbath. The Toby Clark was referring, out of heat and rational moment, he was referring to hotel staff, correct?
Correct.
They were upset that the hotel staff was facing multiple problems setting up what was needed to be set up.
Yeah, it seemed that way.
Your Honor, I have no further questions to this witness. And then my witness, please. Yes.
Call Dr. Parker Turner to the stand.
Good evening. Please state your name and occupation.
Good evening. My name is Dr. Parker Turner, and I'm an independent forensic pathologist, meaning I investigate criminal evidence to determine a victim's cause of death.
And what training have you received to be a forensic pathologist?
In college, I studied chemistry, but decided to pursue medical school after a few courses with some bio professor I really liked. I then went to residency and completed a fellowship in forensic pathology at the medical examiner's office in Raleigh. I also have a thorough background in police investigation techniques centered around technology.
And do you have any experience testifying in court?
Yes, I occasionally use my experience to testify, but I've never seen a case in which a champagne saber was used as a murder weapon.
And how did you become involved in this case?
I was asked to review all relevant evidence collected by the police department from the crime scene, along with the medical examiner's statement and autopsy.
First, I'd like to talk about the fiber analysis. What is your opinion on the fiber evidence that the prosecution has presented?
Well, I think it's important to note that this evidence can't always be trusted, so it's hard to draw a very accurate conclusion, especially in a case like this where so few fibers were collected.
Is there any way to know when the fibers were transferred?
There isn't. I'm aware Mr. Sunshine gifted the scarf the morning of the day he was killed, so the fibers could have been transferred at that time, but there's no way to know for sure.
Are you aware that the police found a shoe print near Mr. Sunshine's body?
I am. However, it was partial and smudged, which made it difficult to figure out whom the shoe belonged to.
Just to be clear, is there any way to indicate that the shoe print belonged to Toby Clark?
No, the detective did not recover shoes from any of the witnesses to find a match, but the dimensions indicate it was between sizes 41 and 42 European.
Next, I'd like to talk about the geofence technology. What is your opinion on the reliability of the geofence?
I'll admit, modern technology these days is pretty impressive, but it does have its fault at times, especially in what we call an urban setting like the Bells Hotel.
And what effect does an urban setting have?
Well, tall buildings usually have a high degree of traffic, with many floors interfering with Wi-Fi and satellite GPS. That means even if it placed her in the room, it's definitely possible that Miss Clark was on a different floor.
Are you aware of the fingerprints found on the champagne saber?
I am. There were two sets of fingerprints. The first, belonging to Miss Clark, near the blade of the saber, and a second, unidentified set on the handle.
And in your opinion, how much force would it require to fatally injure someone using a champagne saber?
Even though saber sounds like a menacing weapon, champagne sabers are only used to knock the cork off the bottle, so they tend to be relatively blunt. In my opinion, it would take a significant amount of force to stab someone fatally with such a tool.
And are you familiar with the pre-existing injury to Toby's shoulder?
I am. After viewing Toby's MRI, I noticed a great deal of scar tissue, consistent with an injury she reportedly sustained in college. I also noticed withering around the muscle of that joint, which means that even if it was an old injury, it would still hinder heavy use of the shoulder.
And what is your conclusion about the evidence in this case?
This is a classic case of people getting ahead of their own evidence, and even Dr. Vasquez agrees on a few fronts. There was no match for the shoe print, there was no match for the second set of fingerprints, and fibers can tell us nothing. The shoulder injury would make it extremely difficult for Miss Clark to murder anyone in this manner.
Thank you, Your Honor. No further questions.
Yes, Your Honor. Dr. Turner, you've stated you have over 20 years of experience as a forensic pathologist.
That's correct.
However, you've only occasionally testified in violent crime cases.
Yes, but I have over 20 years of experience, so I wouldn't consider myself unqualified.
In fact, you spend the majority of your time teaching anthropology, correct?
It is my main career, but I still do practice forensics and have extensive training in it.
Not dealing in the ruling or examination of homicides?
No, I'm not a medical examiner or judge, but my job is to examine forensic evidence.
And you'd agree that dealing with homicide investigations requires a very different set of skills than teaching anthropology, correct?
Yes, so I guess you could say I'm multifaceted.
Now moving specifically to your involvement in this case. Unlike Dr. Vasquez, you never personally examined the victim's body.
No, but viewing her autopsy report and witness statement was sufficient enough for me to draw my conclusions.
In fact, you never personally examined any of the physical evidence from this case.
Viewing the exhibits was enough, but yes, I did not personally examine the physical evidence.
Now, Dr. Turner, it is in your opinion that it would be difficult for the defendant to wield the saber given their shoulder injury, correct?
Yes, even though the injury was old, the scar tissue would still interfere with strenuous activities, such as wielding the saber.
And you came to this conclusion based on the assumption that the saber used was dull?
Champagne sabers are generally dull because they're only used to knock the cork off the bottle.
So based on this logic, the sharper the edge, the easier it would be to inflict this wound.
Yes, that's how weapons work.
Are you aware there was a specific saber found at the scene of the crime?
I am. I examined the exhibit.
And are you aware that based on her examination, Dr. Vasquez testifies that the saber used was sharp?
Yes, however, sharp can be relative. If the champagne saber was as sharp as other weapons, it would slice through the cork, not knock it off.
Finally, Dr. Turner, even with your assumptions about the saber, you were merely able to state that the action would be difficult and painful, yes?
Yes, given the shoulder injury, it would be extremely difficult and painful.
But not impossible?
Not impossible, but not necessarily more probable or plausible.
Even if it was difficult, even if it was painful, it was not impossible.
Not necessarily.
Thank you, Dr. Turner. No further questions, Your Honor.
Any redirect?
No, Your Honor. May my witness be excused?
Yes, they may.
The defense would like to call Nick Yang to the stand. Good evening.
Good evening.
Please tell us your name and occupation.
My name is Nick Yang, and I currently work as an entertainment lawyer in New York City.
And do you know Toby Clark?
Yes, we went to law school together. I've known Toby for about 20-ish years, and I've considered her to be a dear friend.
So now Toby is accused of murdering Kieran Sunshine. Do you have any personal knowledge about this case?
No, I can't believe they would accuse Toby of such a thing.
What was the nature of your relationship in law school?
Well, Toby and I worked together in pro bono health clinics where we would help assist attorneys with their research and writing for their cases.
And have you worked together since law school?
No, although I did try to convince Toby to join me as a patent attorney because it pays very well, she respectfully declined.
How do you and Toby keep in touch?
Toby and I made a pact to meet each other at least once every year after graduation, but both of our work has been keeping us both very busy lately.
Are you aware of Toby's current work?
Toby currently works at SMC fighting for more environmentally beneficial healthcare practices. She's always talked about wanting to fight more unfair private healthcare practices, and it's so great to see her taking on more pro bono cases.
So you went to law school, Toby, you worked with Toby, and you've known Toby for 20 years. How would you describe her character?
Toby's an empathetic, generous, and selfless person who always fights for those in need. She told me in her first year in law school that she wanted to become a patent attorney to help improve society. She's a straight talker, always to the point, always honest. I mean, I can't believe Toby would be accused of murder.
Thank you. Your Honor, I have no further questions.
You and Toby Clark went to law school together, correct?
Yes.
And you described Toby Clark as someone who does everything by the book.
Yes, that's true.
But that was a long time ago in law school.
It was, but we have been keeping up through social media.
Isn't it true that you both had thousands of dollars in student debt?
Yes, that's what law school does.
And you'd agree with me that those student debts don't just miraculously disappear.
No.
You need to pay them off.
Yes.
And you need money to do so.
That's true. Money is used to pay off student debts.
Moving to July. You would agree with me that you can't tell the courts anything that happened the night of July 16th at the Bells Hotel.
No, I cannot.
Right, because you were not at the Bells Hotel on the night of July 16th.
I was not.
You never worked at SMC?
No.
And you never met Kieran Sunshine?
No.
In fact, there was only one person you knew involved in this case, Toby Clark.
Yes, that's true. I know Toby very well.
But you would agree that you haven't seen her in a number of years.
As I said earlier, me and Toby keep in touch through social media platforms.
But have not seen each other for a number of years.
It has been a little bit, but yeah.
Thank you, Your Honor. No further questions.
All right. Any redirect?
No, Your Honor, we ask.
Yes. Our next witness.
Your Honor, the defense calls Toby Clark to the stand. Good evening. Please state your name and occupation for the court.
My name is Toby Clark. I'm a patent attorney and a past employee of Sunshine Medical Components, where I worked for 8 years.
What are your responsibilities at the company?
I advise on legal matters, from preparing and negotiating company contracts to submitting patent applications. I most recently worked on the Forever Flex joint replacement with Kieran Sunshine.
What was your relationship like with Kieran?
We were coworkers and friends. We had been through so much together and spent so many late nights preparing for the Forever Flex presentation, which was supposed to be on July 17th.
Did you have a meeting with Kieran on January 3rd, 2023?
Yes, I believe we did.
And what did you discuss at this meeting?
Well, at this meeting, Kieran told me that the results of the trials were good. He mentioned that there was a small hiccup, but he told me not to worry about it. Given that he was the CEO, I trusted him.
And what did you proceed to do?
Well, given the positive results, I filed for the patent. I started talking with distributors and with hospitals.
Why didn't you look into the product further?
I trusted Kieran, both as my friend and as CEO. But honestly, it was my mistake. I should have looked into it further.
Moving on to the morning of July 16th, could you briefly describe what happened?
Yes, we met in Kieran's hotel room early in the morning, and that's when I gave him the champagne saber and the bottle of champagne. In exchange, he gifted me this beautiful silk scarf.
And what happened after this exchange?
Well, after the exchange, Kieran admitted that he had been lying to me about the progress of the Forever Flex. He said it had been causing bacterial infections in patients, and that it would take another year to fix.
How did you react to this?
I was shocked. If I had known about this, I never would have submitted the patent application.
Why wouldn't you have submitted them?
Well, first of all, that's illegal, but Nick and I in law school worked with victims of medical malpractice. I knew how a defective product could impact a patient's health, and I went into the industry to help people, not to hurt them.
What happened after Kieran told you about these defects?
We got into an argument. Kieran wanted to hide the results from the board, but I tried to convince him to be honest.
What happened after this encounter?
Kieran and I set up the meeting space around 1 o'clock, so that was when we saw each other next. There were some issues with the projection screens, so we were both a bit frustrated.
And what were your reactions to these issues?
Well, I said if this doesn't get fixed, there's going to be a bloodbath. It was unnecessary, but I was just frustrated. That's it.
Did you go anywhere else that day?
Around 11 p.m., I went to the gym, and I got back a little bit before 1 a.m. I finished up my night like normal with some stretching and meditation, and I went to bed.
Let's talk about the following morning. What did you do then?
I woke up early, and I decided not to attend the meeting. Instead, I ran some errands.
Why did you decide against going to the meeting?
Kieran was going to lie about the Forever Flex. I couldn't be associated with that.
Were you questioned by the Kingsley County Police Department after Kieran's death?
Yes, I was. I went to their station on July 19th, and there I gave them my fingerprints and DNA. They also asked me to provide Magnate's shoes, but I had donated them many months prior.
What happened on August 3rd, 2023?
Detective Heron came to my house and arrested me for the murder of Kieran Sunshine. I was shocked. I had no involvement in this.
Miss Clark, did you murder Kieran Sunshine?
No, of course not. Kieran Sunshine was my boss, but more importantly, he was my friend. This situation is unimaginable, and I'm truly devastated by the loss of Kieran.
Thank you, Miss Clark. Your Honor, I have no further questions at this time.
Cross-examination?
Yes, Your Honor. Now, during your time at SMC, Amari was VP of Research and Development, right?
Yes, he was.
And you believe she took this job because she didn't want to do any real work?
That was something I observed about her, yes.
And you were also aware that she knew she could easily take over as CEO with the help of the board?
Yes, we were both aware of that fact.
And Kieran told you the Forever Flex test results were positive when you met with him on January 3rd, right?
Yes, he did.
And you and Kieran were the only ones at this meeting?
Yes, we often had one-on-one meetings like this.
Now, you had access to the test reports throughout the entirety of the Forever Flex test or product development, right?
Yes, I did.
But you never really looked at them, did you?
Unfortunately, I did not, and I regret that every day.
You just took Kieran at his word, right?
I did.
Now, let's transition to March. In March, you were presented with a heavily redacted Forever Flex report, right?
Yes, I was.
And at this time, you were also aware of a problem with the product?
I was told there's a small issue, but I assumed it was fixed. Kieran took control of everything.
Now, you mentioned earlier that you've been SMC's in-house counsel for 8 years, and isn't part of your job to do due diligence on products before filing patents on behalf of the company?
It is. I did not do my job to my full capabilities, and I regret that.
And you heard Nick Yang testify earlier that you do everything by the book, and this wouldn't really be doing everything by the book, wouldn't you agree?
I try to. I put too much trust in Kieran.
Is that a yes?
Yes, it is.
Now, Ms. Clark, do you remember how much you stood to gain financially if the Forever Flex were to be a success?
If the Forever Flex were to be a success, which it wasn't, I would have gained, I believe, a 7-figure bonus.
Thank you. And now let's discuss July 16th, the day before the IPO board meeting. You met with Kieran alone that morning, right?
Yes, again, we had many one-on-one meetings.
Now, Ms. Clark, let's assume, as you claim, that you had no prior knowledge of the fraud with the Forever Flex. This is when Kieran told you about the problems with the product, right?
Yes, he did tell me about the problems that day.
And that he planned to keep them hidden from the board?
He did.
So this is when you realized that your patent was fraudulent.
Yes, I realized it had incorrect information.
And you could be charged with making false statements to the federal government?
Yes, I could. We all could be liable.
And you could lose your job, right?
I could.
And the Forever Flex wouldn't be released?
Thankfully, it would not.
And the company wouldn't go public?
No, it would not.
You wouldn't be able to help all those people you wanted to help, right?
Unfortunately, I wouldn't.
And you wouldn't get that 7-figure bonus, would you?
My job was never about the money, but I guess that is correct.
Now, let's talk about that night. You claim you were at the gym, correct?
I was at the gym.
But you were alone, right?
I guess I was. It was pretty late.
And you claimed that your phone was dead?
It did die.
But no one can corroborate that either, right?
I guess not.
Now, Ms. Clark, after Kieran confessed to you, you felt like he had lied to you throughout the whole process, right?
Yes, he did.
You felt like he had abused your friendship?
I agree that in many ways he did.
You were facing all of these consequences for the Forever Flex not working?
Yes.
And because of this, you felt betrayed by Kieran Sunshine, isn't that right?
He betrayed my trust, and that hurt, but he was my friend.
Thank you, Ms. Clark. Your Honor, no further questions.
Can you redirect?
Yes, Your Honor. Ms. Clark, you heard from Amari Sunshine today that she had known about the patent since February 13th. And could you tell us when she went to you and asked you about the redacted report?
She came to me in March.
Thank you. Your Honor, I have no further questions.
All right.
Your Honor, may my witness be released from the stand?
Yes.
The defense rests their case.
Are we prepared to proceed to closing arguments?
Yes, Your Honor. betrayal that led to the ultimate decision. Convince or kill. It is easy to rationalize a wrong decision with the promise that the ends will justify the means. It was all too easy for Toby Clark to justify their secrets and their lies. They were merely expediting a patent. The product would be fixed eventually, and they could save the company they had dedicated their career to. The company she had seen help so many. And let's not forget, she had a 7-figure reason motivating her silence. So it was all too easy again on the morning of July 16th. After finding out about Kieran threatened to destroy their conspiracy, after he had betrayed their friendship, their loyalty, and their trust. For the defendant to decide there's only 2 things she could do. Convince Kieran Sunshine to stay silent and salvage what they'd worked so hard to accomplish. Or, in the case of failure, make the ultimate sacrifice and kill Kieran Sunshine. Tonight, the people have satisfied each element of CalCrim 521 first-degree murder by presenting evidence that demonstrated 2 facts beyond a reasonable doubt. That the defendant committed the act that ended Kieran Sunshine's life, and that she did so with willful, deliberate, premeditated intent to kill. The people have proven that Toby Clark had the capability, the opportunity, and the motivation to commit this crime. Dr. Casey Vasquez testifies that without a shadow of a doubt, Toby Clark was physically capable of committing this crime. And even Dr. Turner, the defense's failed attempt to contradict this conclusion herself, admits only that the injury could have made the act difficult or painful. And if somebody has sufficient motivation to take another man's life, it is simply unreasonable to conclude that a little pain or a little difficulty could have stopped them. Second, the opportunity. Miss Clark knew that saber was in the hotel room, having delivered it themselves earlier that morning, and they knew Kieran would let them in later that evening. But from each and every witness who saw or heard them together that day, the story is the same. Shouts, anger, threats. The defendant still trying to find a way to convince Kieran that their secret must remain hidden. But time was running out, and one way or another, Toby Clark could not let that secret leave that hotel room. It was a desperation, fueled by greed, fear, and betrayal. Because that morning, Kieran was not only threatening to destroy any hope of the money Miss Clark had fought for, but her livelihood as a whole, leaving her vulnerable to criminal charges and termination from her position at SMC. Now, opposing counsel has spent a lot of time this evening arguing that she never knew about the attempted fraud. But I would like to ask Your Honor to keep one thing in mind. It doesn't matter. Toby Clark is not charged here today with fraud. Whether Kieran had betrayed their conspiracy or their friendship, had roped them into a plot that jeopardized their morals and their position, it was betrayal all the same. Betrayal that Toby Clark admits to feeling. Betrayal that they lived with all day on July 16th. Betrayal they were hoping they could still avoid if Kieran would just stay silent. Willful, deliberate, premeditated. Having proven that the defendant committed the act, these are the final elements under CalCrim 521 that the people needed to prove to secure a conviction of Penal Code Sections 187 and 189. And they have done so through the demonstration of 2 facts beyond a reasonable doubt. First, this was without question an act performed with the intent to kill, seeing as Kieran Sunshine was stabbed in the abdomen 6 inches deep with enough force to penetrate liver and dent bone, seeing as he was left to bleed out on the floor of his hotel room without medical attention. Second, the people have proven that this was not impulsive nor a rash decision, but it was calculated. Came to by weighing the consequences of Kieran coming forward to the board. Consequences weighed that morning when they were first met with Kieran's betrayal. Consequences weighed throughout the day, embodied through the phrase, "This better be fixed or there is going to be a bloodbath." Consequences that led to the final decision, convince or kill. For these reasons, the people ask you find Toby Clark guilty of first-degree murder under CalCrim 521. Thank you.
Defense?
Yes, Your Honor. May I proceed?
Yes, you may.
Growing up, we all remember being taught to do the right thing. Clean up our dishes, do our homework, look out for others, and always tell the truth. Your Honor, this case is about several people who did not do the right thing and the one person who did. Just as my co-counsel has told us we would, we have seen the prosecution fail to prove first-degree murder and have instead proven 3 simple truths. Toby Clark is kind, Toby Clark is caring, and Toby Clark works to do the right thing. We have established a few key things in this case that should point to an obvious conclusion. You heard from Ari and Sunshine describe the shares Amari inherited, the title of CEO they claimed, and the numerous of other examples of how they undermined and belittled Kieran's success over the years. Now contrast that with Toby Clark. Her oldest friend, Nick Yang, showed us that Toby has always chosen people over profits, care over career. And when combined with the limited and inconclusive evidence tonight, it is clear that the prosecution's burden of proof has not been met. So let's review the prosecution's case. To start, they counted on someone proven to be unreliable in the past and in the present, and not a person worth your trust. And why is that? Jerry Moyed is a confessed liar and even admitted on the stand that they did not trust Toby Clark. Your Honor, their word is the only evidence that Toby was involved in Kieran's fraud scheme. Their word is the only evidence that Toby and Kieran fought that night, and their word cannot be trusted. Even if Toby and Kieran did fight that night, Jerry Moyed was 20 feet away behind a closed door next to a running shower, and they can only say that they are almost positive the voice they heard was Toby's. That's a guess, and a weak one at that. Detective Perrin's investigation is far incomplete. To start, they got tunnel vision when speaking specifically to Jerry Moyed. They focused on Toby Clark to the exclusion of all others. And to just take Amari's word for it that it must have been Toby in the hallway that night, despite Amari not even being sure, their lack of due diligence is a sin of omission, but it has proven costly all the same. What about the physical evidence? Sneaker, saber, fibers, phone. As Dr. Turner walked us through tonight, it became clear that the prosecution has reached to specific conclusions, unsupported by broad data. So let's review it piece by piece. Saber. Toby Clark handled the saber when they purchased it and gifted it to Kieran. Of course their fingerprints are on the saber. And by the medical examiner's own admission, there was another set of fingerprints on the saber that could literally belong to anyone and could have been left there at any time, including by Amari Sunshine at the time of the murder. Now, let's go back to the sneakers. Let's remember one key thing here. Amari Sunshine claims that they lost their sneakers. No evidence to back that up. Now, what about the fibers? The fibers ended up on Mr. Sunshine's sleeve with no time and date of when they arrived. For all we know, they could have been arrived in the morning when Toby gifted the silk scarf to Kieran Sunshine. And the prosecution even agrees in stipulation 9 that Mr. Sunshine wore the same suit the entire day, including when they gifted the silk scarf to Toby. And no one ever checked if Amari owned any silk. Phone. It's impossible to know whether Toby Clark's phone came from the hotel gym on the 10th, on the hotel gym on the 9th, or their hotel suite on the 10th floor. Simply put, Your Honor, the prosecution's evidence, physical or in testimonial, in part or in whole, do not rise to the level of beyond reasonable doubt. Your Honor, the most fundamental element of CalCrim 521 is proving the defendant committed the act, and the prosecution is nowhere near doing so. Whether it's means, motive, or opportunity, the prosecution has not provided any evidence that cannot be reasonably explained. And even if you did take everything they've said tonight at face value, they've still presented no evidence that that Kieran Sunshine's murder was planned, premeditated, or reflected upon the way in which CalCrim 521 demands. They not only are nowhere near proving murder, they are nowhere near proving it in the first degree. Your Honor, the people claim that Toby Clark was alone that night. So was Amari.
The people also claim Toby Clark has a financial incentive. But what they conveniently failed to tell you was that Toby Clark was going to leave SMC and withdraw his patent, thus eliminating his financial incentive, and what the people claim was that led to his ultimate decision to kill Kieran. While they didn't reference, Amari Sunshine stood to gain billions of dollars and the title of CEO that they had claimed and envied their entire life. Your Honor, let's remember, without any conclusive evidence to separate one from the other, therein lies reasonable doubt. People don't just change overnight. They can't. Tonight, you heard Amari was cruel. Amari undermined and belittled Kieran, and Amari Sunshine did not do the right thing on July 16th, 2023. Now, you also heard Toby Clark is kind. Toby Clark trusted Kieran, and Toby Clark didn't. And Toby Clark worked to do the right thing. That is the Toby Clark you have seen tonight. And that is the Toby Clark we implore you to see the reasonable doubt and find him not guilty of first-degree murder. Thank you.
Do we have a rebuttal?
Yes, Your Honor. The defense has tried and failed to prove the three things they promised: that Clark is caring, Clark is trusting, and Clark always tries to do the right thing. The defense's only character witness, Nick Yang, is simply outdated and hasn't spoken to the defendant in years. Their own expert, Dr. Turner, could not even deny the fact that despite the shoulder injury, Toby Clark still had the capability to commit this crime. As for Aryan Sunshine, she is simply one of many cheap attempts to implicate Amari Sunshine, who, despite what the defense argues, had no motive and very little forensic evidence against her. And finally, Toby Clark, whose own story could not be corroborated by a single person in this case. Therefore, the people ask you find Toby Clark guilty of first-degree murder. Thank you.
Yes, Your Honor. Let's start with people's second to last point. Nobody could corroborate Toby Clark's location. Neither could anyone for Amari, who is, by the detective's own testimony, was named a prime suspect. And as the people claim, they've said that he willfully and premeditated killed Toby Clark. First of all, that's not true, as if someone were to willfully kill someone, they have to have motive. And as I've stated, Toby Clark was going to leave the company and he was going to withdraw his patent, thus eliminating his financial motive for murder. In addition, let's go back to reasonable doubt. There are so many points of reasonable doubt here that multiple points of evidence do not connect just to the defendant, but connect to multiple people in this case. Let's start with the footprints. Everyone, Jerry Moyad and Amari Sunshine, fit into the shoe size of a 41 to 42. By any means, and they also have motive. As I've said, Amari Sunshine stood to lose billions of dollars, lose the thing that they once had the opportunity to claim and that they have wanted their entire life. Jerry Moyad would have lost their job if the company went bankrupt. Therein lies two people with a stronger motive, while my client has none. Your Honor, the people rest their case, or the defense rests their case.
So I am just going to very quickly deliver a ruling. Obviously, this is going to be based on the facts of the case that were presented tonight, not how they were argued. I think everyone did a great job. But I think the prosecution kind of pulled the short end of the stick on this one. And with first-degree murder as the only charge, there is simply not enough evidence. So I'm going to rule in favor of the defense, not guilty. Right. All right, so that's everything. Thank you everyone for coming out and supporting Notre Dame mock trial. Congratulations to all of our new members, all of our people who this was their first trial. I think